call us and say, I'm struggling. And again, we will say LCL is a tremendous resource and try to put them in touch with each other.
And how often do we call you about somebody?
Never. And that is a good thing. And here's what I mean. We have certain confidentiality rules that govern what we do, but in these kinds of circumstances, we do reach out. Now, one of people's fears, of course, is if I go and I bare my soul to LCL, to one of their programs, to a provider that LCL might refer them to, there's a real concern about the board is going to know. And as lawyers, we have an obligation to report serious misconduct we know about. And if someone comes to Joan and says, Joan, you're a lawyer and you're at LCL and I stole a whole bunch of money, there's an exception on that duty to report. And it's for the Supreme Court approved lawyer assistance program, LCL. So Joan is not going to call me up and say, Tim, I got one for you. Nor if I send Joan a letter or something to say, Joan, would you please be so kind as to tell me what you might know about what this lawyer did? Joan will write me what I hope is a very nice letter and say no. Now, we don't actually write these letters because we know this. And I say this to illustrate the point that the confidentiality around LCL is really strong. So if you're having problems and you reach out to them or they reach out to you because someone's alerted, you don't need to worry about what you tell Joan being a conduit to come tell Kim.
That's right. There's a one-way communication. It's one way only. And in fact, very early in my time at LCL, I received a letter from a relatively new attorney at the OLPR because someone was claiming mitigation. We'll talk about that a little bit later. In terms of their discipline issue and that they had worked with us and confirmation was being sought. And, you said that I would write a letter or call you. It's like, no, I would call your boss and say, just want to make sure that you've kind of let people know the way it works here. So LCL actually has the strongest confidentiality policy in the country in terms of what we will share. If someone is put on our radar by a judge, by the OLPR, by a colleague, and then they want to know, okay, what happened? Even judges, and they get annoyed by this sometimes. It's like, I can't tell you. I can tell you that this is what happens. This is how we reach out to someone. These are the various ways we would reach out to someone. And I'm not even going to tell you which way we did. And frankly, sometimes someone will tell us to take a long walk off a short plank. I don't need you, I don't have a problem, they're after me, nobody understands, and we will continue to try to reach out, but sometimes they will push back on us too. And we're not going to say, well, we tried to reach out and they didn't get back to us, so, maybe you can reach them a different way. That's the level of our confidentiality, it's absolute. And we help lawyers, judges, law students, and immediate family members. A lot of people don't necessarily realize that on any issue that causes stress or distress. So if you've had that JD behind your name for a while, you might remember LCL as an organization that helped with alcohol. Well, that was the first 25 years. That was kind of what we did. And in the most recent 17, do the math, we've been around for 42 years, 43 this August, we've been dealing with all of those other issues. We expanded. And we will also talk with people who are concerned about someone else. And if you are concerned about a colleague or a family member, and you want to call up and say, yeah, this is what I'm seeing. Should I be concerned? Or how would I talk to this person? And by the way, I don't want to tell you my name. We'll say, okay, we'll have whatever kind of conversation you want to have, and we'll do our best to talk with you about how to reach out to someone you're concerned about. Another thing too that relates to that is that, if you want to stay in touch with us, obviously we're going to have information in order to do it, but we will work with people without you having to even tell us who you are. So that's the level, that's the promise we make of confidentiality. Other services you can get from us is that we provide free counseling. We'll have a slide at the end that gives the actual details on that. We have a 24-hour hotline. You can get assessed for whatever issue might be bothering you. Sometimes it's just, I just need to talk to someone to sort through some things. I'd like to talk this through before it starts to become enough of an issue that it starts to affect my work or it starts to affect my family. And sometimes people need referrals to other services. And it's like, you know, when you're thinking, I'd really like to talk to someone, but I don't know where to start. Well, for those of you who remember Yellow Pages, you know, you open it up under counselors, you close your eyes and you point. I mean, that's kind of what we know about how to find a counselor. Well, you can call us and we'll get you started. It's almost like triage. You meet with one of our counselors and they say, okay, maybe you can work through the issue in those 4 free sessions we provide. Or maybe it's, you know, I think it's going to help you to work with someone on an ongoing basis. Let's take a look at your insurance. Let's see who's in network. Let's look at what sort of clinic is within, and let's look for somebody who would be the right person for you there. And so they will help you understand what kinds of resources are going to be most helpful. We also have groups. I really want to call attention to one called The Path to Lawyer Wellbeing. We'll talk about that in a minute, but it's a group that meets once a week, and you can come to any or all of the sessions. I think we're in about session 6 now, and it's 4:30 on Tuesdays, and it's at our office, and you can participate by phone. So if you go to the LCL website, it's right there on the home page, and you'll be able to see that. And then we also have a lot of social support and peer support that's available. So one of the things that we want to call people's attention to is a report that was issued just about 2 years ago called The Path to Lawyer Wellbeing, Practical Recommendations for Positive Change. And this was from the National Task Force on Lawyer Wellbeing, who said, we're going to create a movement to change the culture in the legal profession because we do have issues with the kinds of problems that we have in our profession. And I'll go into what those things are in a little bit. But this was created because we had these statistics that showed that we had higher levels of substance use and mental health issues than average. And so are we going to put those reports on a shelf, or are we going to try and do something about it?
And that's what, you know, this is definitely a report that has not landed on a shelf.
No.
Nationally or in this state. I've been practicing a while. As I said, I've been at OLPR for 26 years. And there are reports that come out all the time about this, that, and the other thing. And many of them have maybe a little traction initially, but a very short half-life. Or maybe people don't even give them a half-life. They just get put on a shelf and they dust. This one has really landed loudly and in a very sustained way. Nationally, in this state, both with the practicing bar, with our office, and with the Supreme Court as the ultimate overseers of the legal profession in this state. This is something that has legs and is, people recognize just how important what this report says and what its implications are.
So the task force came up with 3 reasons that they thought would resonate with people on why we should be doing something, why we should not accept the status quo. And the first one is simply organizational success. Any kind of organization where lawyers are working, the amount of human energy and the cost that goes into both dealing with people who are struggling because they didn't feel like they could get help before it became a crisis, as well as replacing, if that needs to be done. All of that energy that goes into it. And by the way, I was talking to a law firm today where they said, you know, our malpractice carrier wanted to know what we have in place to give people permission to ask for help before it becomes a malpractice issue. So it's a financial issue. It's starting to be seen that way. I talked to a general counsel who said, when I have an assignment and I happen to get around to sending it out on Friday, I don't want it on Monday. I don't want burned out thinking. I want best thinking. And so they're thinking about, if it's a crisis, yes, we want our outside counsel to treat it like that. But if it's something where, well, it's the end of the week and I got around to setting out this assignment, they don't want an associate missing their kid's birthday party because they worked on this thing because a partner handed it to them at 4:15. So that's the kind of way that it's being recognized as a financial issue. The second reason was because well-being is definitely related to ethics and professionalism. And Jim, maybe I'll let you just kind of run with, what are these rules, and why do you think that they are related to well-being?
On a very high level, Rule 1.1 says as lawyers we have to give a legal matter the thoroughness and preparation and knowledge and skill that it requires. And if we're suffering from a lack of well-being, whether it's mental health or substance use, or I have 2 badly herniated discs in my neck that I'm not taking care of, and I have shooting pain all the time and I can't think straight, or whatever it is, that can affect our ability to be competent. We give it the adequate attention that whatever it is we're working on requires. Rule 1.3, and I think intuitively this is the one that flows most for people. We have obligations as lawyers to handle whatever we're working on, a legal matter, with adequate diligence and promptness. I think intuitively most people can say, I get that one. Someone who is suffering from an issue with depression or anxiety or alcohol starts to not go into the office, starts to not take care of matters. Things start to slide. Things get moved to the back burner, and now all of a sudden everything's on the back burner, and those kinds of types of situations that we see, bad enough, can also lead to other issues because I've neglected some things, and this is late. And I've missed a deadline, whether it's a court deadline or a boss deadline or whatever it might be. And now what do? I have 2 options. I can go tell someone that, gulp, I didn't do this on time. Or I can start to fib. And by fib, I mean lie. And it's a slope. And not everyone falls down that slope into lying, but we do see that. Where someone on one or more things, it gets away from them, and then they just don't want to face up to the truth. So then the lies start to come in. And it's just something that doesn't affect just us individually. Those of us as supervisors need to be aware of this and to be seeing this. And when we see performance sliding, we need to be thinking about why it's not just a raw performance issue. Come on, you need to be getting your work done. What's going on here? Why? What are we seeing? Is there something underlying that as well? And if it gets bad enough, and we've seen this, where partners go into a lawyer's office and discover the lawyer had done what I just said, neglected something and then lied about it. Well, now all of a sudden the partner has a reporting obligation because this is serious, and they know for one reason or another that the subordinate lawyer lied. There are real consequences that can flow here, not just well-being issues, but the title of the seminar, when is well-being an ethics issue? Here we are. Suddenly it can face us square in the face. And my example was in a private firm, but it's not just private lawyers. It can be any setting of lawyers.
And there's so many reasons that might happen. It might be that there was something in that case that reminded you of something that happened when you were younger and you just can't deal with it. I'll talk about that in a minute when I'm talking about stress.
Or it could be my kid is really sick and I'm just not able to focus at work and I've kind of shut down.
Mm-hmm.
And it's that stress has become so extreme and overwhelming that all I can think about is that.
Yeah. And so those are the kinds of things that saying this is what happened, or I need a break, or even calling LCL and saying, how do I have a conversation about this? Because you don't have to go through this alone. And then it's also, the third reason is that it's the right thing to do. So when we look at lawyer well-being, what the report did, and by the way, I sent Liz this gigantic packet, and is that going to be posted online? Yeah, okay. So instead of, printing off this thing that's half an inch thick, it's available online. So this exact document is something that you can look at, and the PowerPoint I think will be posted too. These are the elements of well-being that were identified by the task force. And if you look at the top two, occupational and intellectual. Those are the things we think of as important as lawyers, right? That's what I'm smart, I think well, I analyze. Okay, I'm a lawyer. Yes, that's what I do. That's what we value. And all of this other stuff, you know, spiritual and emotional and physical and social, it's like, well, that's okay. I'll get around to that when I have time, maybe, but it's not as important as I'm an important thinking lawyer. But if you look at this as this diagram and you imagine that the top two, okay, that's the part you're paying attention to, but the bottom four, you notice they're kind of curved. And I want you to think of that like a boat. What happens if there's a leak in your boat? You're not thinking about your best thinking, you're thinking about the leak in the boat. And it could be anything. And so rather than dismissing the emotional and the social and the physical and the spiritual, rather think about where is your boat the strongest and where does your boat maybe need some work. And then you'll be able to float well on top of your boat and do your best thinking. So that's kind of the way I like to talk about that one. Another diagram I'll show you in a minute, it gives us a different way to look at this. So kind of looking at you know, what stresses us out? What hits us as lawyers? And you can think about the things where, okay, it's the adversarial system, you know, there's new things I have to learn all the time. There are things like that, but these are some personality factors that tend to affect us most as lawyers. First of all, and I think very importantly, is perfectionism, where we don't want to have somebody else see us fail, and therefore we will lie. Because the idea of showing somebody that we made a mistake, admitting we made a mistake, having somebody else find out is too great for us. And so we think we have to be perfect. And in fact, you know, you learn in your first year of law school that if you blow a statute of limitations, it's malpractice. So perfection, perfection, perfection. Well, guess what? You're more likely to become depressed because nobody's perfect. And in your typical legal case, you look at your facts and you look at your situation, you say, all right, I want to reach for the sky. Well, you're never going to get the sky. But sometimes if we get turned around enough, we think that unless we get the sky, we failed, when in fact, nobody ever gets the sky. And I expect that many of you are law clerks or you're working in situations where you're not necessarily actively adversarial, but you're watching this. And you're watching these arguments where it's like, it's absolutely unreasonable not to give me the sky and the sun and the moon and the stars. It's like, well, you're not going to get that. And yet people can't back off and say, you know, what can we do to work this out? They lose sight because of that perfectionism. Another thing that I think is particularly unique to us is that we are pessimists, or at least we should be if we want to do our best work. Because our job is to see everything that could possibly go wrong. Think about that. You know, the best lawsuit anticipates every damage. The best contract anticipates every breach. And so that's what we're looking for, is we're looking for the things that could go wrong. But the thing about pessimism is that, and by the way, optimists get better grades in every graduate program except one. Lawyers get better grades when they're pessimists. Just saying, so there is a payoff. But we tend to also say there's nothing that anybody can do about it. And so that can be a struggle for us to be proactive, to say, you know what, nobody's going to do anything about this except me. And I'm not happy about how things are. Isolation and uncertainty they are similar in the ways that they manifest, in that the more we isolate, the less self-assuredness, self-esteem, and confidence we have in ourselves. And so those two things can combine. And I would bet that isolation is a really big factor in what comes into your office.
We deal with a disproportionately large number of solo or very small firm practitioners. The cynics in the world will say that's because we favor the big firms. Not. It's because a solo practitioner really has to work a lot harder to find a support network. I work in, we have 13 lawyers 12 lawyers in our office right now. I can go down the hall and say, can I talk to you about this issue? Can I talk to you about this case? Can I talk to you about this person I'm having to deal with who's driving me nuts? Or can I just take 5 minutes and tell you about what's going on in my life because I just need to vent, okay? If you're a sole practitioner, that's much harder, especially on the client matters, given our duty of confidentiality. And we may be physically limited if we're a solo practitioner. You know, the next lawyer may not just be down the hall. And if you're in a small town, it can be that much harder because there's not a large pool of lawyers and there may be a lot of adversarial, professionally so, relationships because of the number of lawyers. So yeah, we do tend to see people who suffer from one or more forms of that kind of isolation.
And then we are exposed to other people's trauma. Think about it. People are, the worst things that happen to them, they need to see a lawyer. When they are feeling worst about themselves in the world, that's when they're seeing a lawyer. And sometimes their behavior, they may not behave in the way that their best selves would behave, and that's what a lawyer sees. So we see all of those details, and of course, first responders and others see trauma too, but often people in the legal profession are spending more time with it. They're giving more attention to it. And
I say, and people in this field have that issue too. You know, if you're a law clerk and you're reading the transcript of a horrible criminal sexual conduct case, and maybe the victim is an 8-year-old who's testifying, or maybe it's a child pornography case and there's video or photographic evidence that you're having to look at for some reason. I mean, that is a form of vicarious trauma. You're having for a murder case with some graphic evidence and graphic testimony. That can be traumatic to have to look at and to review and to deal with, and they have to write about. So, you know, people here can be suffering. That's another form of potentially vicarious trauma. And I think it's an area, you know, whether it's prosecutors, whether it's judges, whether it's law clerks, that the profession has not spent enough time to say, is this an issue for people? And if so, how do we deal with it?
right. And one of the things that I have heard that often law clerks will do, and I don't know if this is a case in every courthouse, and of course, if you're a one-judge county and you're online, this isn't available necessarily. But if you are in charge of cataloging evidence in a difficult case, let's say an appeal has come in or something like that, you shouldn't do it alone. And it's something that I've heard, and I don't know if it's still the case, but that law clerks will help each other out. And you know, you're not necessarily going to watch a video, but you might have something that's got an evidence tag on it that was part of the crime, and you've got to confirm that it was in the box that you are looking at. And so you can have someone with you to do that. And I think it's very much okay, and I think that should be the culture, that people don't have to do that alone. I think that's important because it can have that impact. And, you know, I mean, doctors deal with trauma too, but they don't have someone on the other side of the patient trying to pull out the stitches. And that's what you're dealing with too, is this adversarial system. Okay, all right. And turn down their background noise. So this is another diagram I would encourage you to look at, and this is kind of looking at well-being. There's the challenges on one side and there's the opportunities on the other. And if we look at things with a pessimistic point of view, the ones on the left are going to have all of our statistics. And the ones on the right are going to be, what can we do about this? What's something I personally can do to reduce my risk for this? I encourage you to take a look at that and like what things on this might be part of the thin place on your boat that you might want to try and do something about. So if we're having trouble managing our stress, we're not going to perform as well, and we're going to be more likely to engage in what we call unhealthy coping mechanisms. And I'll give you a few stats, but very few. I'm keeping them in the PowerPoint so that you can look at them yourself, but did not plan to review everything during this session. And Tim talked about the rule on diligence before. I'd like to call attention to one of the comments because the rules govern and the comments guide, okay? But this is the comment. This is the rule. A lawyer shall act with reasonable diligence and promptness in representing a client. And the comment says, a lawyer's workload must be controlled so that each matter can be handled competently. Well, who knew what life balance was in the rules, right? Here's your opportunity to say, all right, I am not able to do my best thinking right now because I've got these other things going on. Therefore, it's my obligation to say, what is it that I need to turn down? What is it that I need to say I can't, that I need to be able to say, what's 1, 2, and 3 priorities, because all 3 things can't be number 1 priority. It gives permission, and I really encourage people to use that. And it may be something, I suppose, in an advisory opinion that you can say, well, here's what the comment suggests.
Yeah. Also recognize that, I certainly can't go to my supervisor and say, I just can't do anymore. I mean, there is work that has to get done, and for those of you who are clerks at the Court of Appeals, you have the 90-day deadline, and others of us have deadlines for a variety of things. But, as Joan said, it is permission to have a conversation with someone. We can turn down work because we have to. Okay, we're going to open up a conversation about how do we make it so that this can get done well, it can get done timely, and it can get done without adverse consequences to the people who are doing this work.
Or I'm having trouble figuring out how I'm going to get both of these things done. How would you handle it? And asking somebody for some guidance, because maybe they've run into the same thing before and they've got a way to do it. You're not the first one dealing with this. And so there are people who can say, oh yeah, I remember that, and here's how I handled it, or here's what someone recommended to me. So looking at the ways we handle our stress, which is sometimes by drinking too much. The ABA Commission on Lawyer Assistance Programs and Hazelden did a survey of lawyers across the country, and what they found was that 20.6% of us drink in unhealthy ways. If you look at people who are in their first 8 years and 30 years and younger in law firms, that's about 32%. Overall, government is a little bit lower overall than average. Law firms are higher. There was no, the data's there, but nobody has gone into it and said, okay, what about new lawyers in government? What about new lawyers in, all of the different areas? It wasn't detailed to that extent, although I really wish it would be. When we talk about what this looks like, it's thinking about drinking or using other substances or compulsive behaviors to the detriment of other things in your life. And having increased tolerance, denying that there's a problem, and not really being able to control on a particular occasion. So you may only binge drink on weekends, that sort of thing, and Mondays are always tough. There's lots of different things to look at. And it's something where, use it for stress. That's early stages. Well, that's what it does. But if you find that you're having trouble reducing your stress without it, then it might be time to look at your use. It's time we start having effects on our work. Right toward the bottom of the middle stage, it says job impact. That's the last thing that's going to go, because we need it to pay for it. So by the time an employer notices, it's pretty far along. In addition to alcohol, we use anything else that we can ingest that has a mind-altering effect. And we also engage in other compulsive behaviors. You would think, gambling is something that is an issue in our society. It's not something we see so much in lawyers, because if you touch a client's money, you're done. And so we kind of stay away from that because we've learned that. But there are other compulsive behaviors. And like the issues in our profession is its own separate CLE, but I want to have these things in here to so that you have this information if you want to refer to the data. Lawyers are 3.5 times as likely to suffer from depression as the rest of the population. Women get help sooner because we ask for help, or as some people call it, asking for directions. And women's depression tends to show up more like sadness, whereas men's may manifest more like anger or anxiety. And we don't quite know what to do with that. There's no societal permission or commercials that talk about it, asking for help when you're pissed off. And yet that can be, is it okay to say that? That can be a sign of depression, more so in men than in women. And the ABA study I referenced earlier 28% of those taking the survey met criteria for depressive disorder. This is during their careers. 18% for anxiety, 23% for stress at a level that might be considered debilitating. And when asked the question, have you ever considered suicide? 11.5% said yes. Now, there was a subsequent question that said, have you ever made a plan? And then, have you ever done something that might have resulted intentionally or accidentally in your death? And those numbers were, of course, much smaller. But this is a reality in our profession, because that perfectionism that says, I can't have anybody see that I screwed up. Some of you may have seen an article called Big Law Killed My Husband, where he was considered a rock star, and yet he never was good enough. And the only way out was to shoot himself in the parking garage of his law firm one Sunday morning. Right now, as we speak, there is a funeral for a lawyer in the southern suburbs who took his life last week. Nobody saw it coming, at least right now. You know, that's what everybody's saying. I had no idea. I had no idea. And yet when you read the depression, the obituary, it said he took his life after suffering from depression. That funeral's going on right now. That's one of us. And so if you see someone and you're concerned about them and they seem off and you just have this feeling, please, please reach out to them and say, are you okay? And if you don't know how to reach out to them, call us and we'll coach you. And if you reach out to them and say, are you okay? And they say, yeah, I'm fine. It's okay, you know, I'm good. Ask again. You know, this is Minnesota. You want some lunch? No, I'm fine. No, really, it's no trouble. I just made it. Well, if it's no trouble, okay. We have to ask twice. So ask twice. Are you okay? Yeah, I'm fine. Well, let me tell you why I asked. This is different. This is something you said. I just have a feeling. I want to know if there's anything I can do. What's going on? And maybe they'll talk with you. One of our volunteers tells the story where he says, I was dealing with depression. I was drinking too much. I was getting to the point where I knew I had to change. I didn't know how, and I was going deeper and deeper. And one of my friends came up to me and asked, are you okay? And I pushed him away. I said, yeah, I'm fine. Because when you're depressed, it's like weights around your ankles walking through water. And the idea of doing something was just too hard. Even saying, no, I'm not okay. But he said, I hadn't been feeling much for a while, because that's what happens with depression. You lose interest. Colors become gray. And he said, but I had this really strong feeling, and I was surprised. And what that feeling was that I wanted him to ask again, because I wanted to change my answer, because I was ready for some help and I didn't know how to get it. So please ask twice. And if you need help knowing how to ask twice, call us and we'll help you through that. Or suicide prevention hotline, 800-273-TALK. This is important because this is what's happening in our profession. In addition to depression, there's anxiety, OCD, bipolar disorder, not being able to function because we're not doing well with our grief, cognitive impairment. And that's another whole seminar about what's happening in our profession as those issues happen. So depressions and unresolved chronic stress is the #1 predictor for depression, and untreated depression is the #1 predictor for suicide. Giving signs, talking about loose ends, anything like that. Be concerned. Ask someone for guidance on how to assess. And if someday you have a client and you are concerned about them being suicidal, you can call LCL as well, and we will talk you through how to assess and how to get that person to help.
Can I just look back quickly? Because there was one thing on that slide that that had the predictor. Keep going.
The suicide
Keep going. Yep.
No, I think I need to go past it.
Okay.
This
There we are. This one.
All right.
You read reports, you see statistics, you see information. You come to these seminars and you hear that and you see slides. But to me, the first bullet when I first saw that information was eye-popping. That lawyers are 6 times more likely that suicide rate. And it's astounding that we might be a little more prone to depression or a little more this or more that. Maybe isn't surprising, but we are more than just a little bit more prone to some of that. But 6 times the national rate is an amazing statistic and ties back to what Joan was talking about, checking in with people that you think are struggling.
This was a Canadian study, and I've actually talked to the director of SAVE, Suicide Awareness Voices of Education, and he said, well, I know it's more for lawyers, but I don't know the stats, and he would not agree to verify this, so we still report this Canadian study because I think it draws attention to it, which, you know, our perfectionism, because most people who attempt suicide don't die by suicide, but perfectionists are much more likely to die by suicide, and that's our profession. So if you are working with someone and you're concerned about them, it's very tempting to try and do things that they should have done. It's very tempting to try and figure something out when in fact you don't have the experience to do it. And they may intimidate you because they're protecting that use. You might have to protect clients and you may have to protect yourself. It may be that it's not going to be a tenable situation anymore, or it may be that that person does get help and is going to be someone that will continue to be a very strong colleague for you. Sometimes people will call us and say, this is what I'm dealing with, we'll talk you through it, but we can't give you the kind of advice that if you find yourself in an ethical dilemma, you might have to call for an advisory opinion. What's that look like?
Lawyers, when you're facing a prospective professional responsibility dilemma, it's confidential between you and me, or whoever the lawyer of the day is answering the phones. And it is confidential, which means the first thing that we're going to ask you is your name. And the reason is we keep a record so that when you later act on our advice and someone says, well, that was stupid, you can say, on such and such a date, I called the OLPR, I talked to Tim Burke, and here's what I was told, and I have some record of that. We get about 1,000 of these calls a year, so you're not alone. We get about 1,100 complaints a year and about 2,000 advisory opinion requests a year, which is good because I think the more of those we get, the less complaints we're going to get because people get some advice to help them through. And we get calls from lawyers about, I had one this morning, a lawyer who represents a client in a criminal matter. The client separately already had a conservatorship. The conservator has resigned and there's no one in place right now. And the client does have some issues. The client wants to fire the lawyer. The client wants money back. The client does not want the lawyer to request a Rule 20 evaluation in the criminal case. I have a client, they're not competent. What do I do? That's an example of what we can do. Or as I indicated earlier, if someone has a concern about a partner or themselves or whoever it might be, a law partner, we can try to give them some guidance, often which includes reaching out to LCL.
And sometimes we say call your PR professor because sometimes they can be helpful too. And when we talk we usually get, well, at the University of Minnesota in Mitchell-Hamlin, they bring us in to talk with the PR classes. St. Thomas doesn't need us. But we will say, you know, and you can call your PR professor if you've got a dilemma like this, right? We get them to nod their heads. So you may find yourself in what seems like an untenable situation. And if that lawyer is trying to protect their alcohol use more than anything else, you might be the one that ends up in trouble because you are discardable. And so be aware of that as you, especially those of you who are clerks, as you move into your next career. I'm just going to jump over these, a couple of these things really quickly because I want to get to some of the things that Tim is going to expound on a little bit more. But you may have things to add. When I was in law school, the director of the OLPR thought that half the cases that came in had an alcohol component. And I asked Pat Burns, who's recently retired maybe 4 years ago, what he thought it was, and he thought it was probably about a third. I don't know if you differ with that.
talking about people that are alcohol use, you know, it's completely unknowable for us. If people don't share, if we're not able to get them help, we don't know, but it would not surprise me at all.
So if it does turn out to be a mitigating factor, in other words, you've got this problem and there's mitigating and aggregating factors, it may be that you're going to have to test, you're going to have to show that you're continuing to engage in abstinence-based support, something like that. For mental health issues, it may be that you've got to show that you're continuing to go to your counselor, things like that. And if you think about neglect and non-communication, just about every lawyer is going to have a client who thinks they should have called them back in 8 minutes instead of 10, or today instead of tomorrow. You know, setting reasonable expectations is pretty critical there. But to the point where a file actually gets opened, that probably isn't a healthy lawyer who isn't communicating to that degree, or who isn't opening and answering the letters from the lawyer's board. That's not a healthy lawyer. So I would say that often these cases, which are a lot of the cases that come in, are mental health issues. One other thing that we like to talk about is anxiety. When you get anxious, it becomes, there's an article about this. It was called An Ethical Sinkhole. You act rashly and in your own self-interest. And that is not going to be good for dealing with a complaint or with dealing with the lawyer who's pushing your buttons. And by the way, one of the things that an advisory opinion can also get you is when your client is asking you to do something that you do not want to do and you know isn't ethical, you can call for an advisory opinion. And they'll say, well, no, you can't do that. And then you can go back to your client and you can say, Mom said I can't do it. And
you laugh. I tell them the rules that you can't. And if you need to, you can go and call the board and the board said, I would really love to help you. That would be great if I could do that. But as Mom says.
Yeah. So as we look at kind of, you know, where do these things happen in terms of the rules? It used to be that the criminal justice system treated this as a moral weakness, and that isn't the case anymore. And we talked about a couple of these rules. Tim, I'm going to let you take over this and talk about it a little bit more, and I'll jump in this time. I think we've got specific slides on each of these.
We do, and we're going to kind of breeze through each of these here. You know, declining or terminating representation. So there's a rule, it's rule 1.16 of the rules of professional conduct. And there are certain situations in which we may not represent a client. For example, if we have an impermissible conflict of interest, we may not. There are special conflict rules for law clerks, which say when a law clerk has to be off of a matter or a judge has to be off of a matter. But one of them is when your physical or mental condition materially impairs your ability to represent the client. The self-assessment is important. The self-awareness is important. The checking in with others is important. How am I doing? Because not only is it me reaching out to someone to say, you know, are you doing okay? It's also me reaching out to others and say, am I doing okay? Because we're not always the best judges of ourselves because we're too close. But if our condition is to the point, and this gets back to the boat and those 6 things, is such that we can't adequately and effectively representing a client, we shouldn't be representing the client. We shouldn't be doing our work.
Before you go on, Tim, I just want to note something. The clock on the wall is actually 4 minutes past, and we started on time for the purpose of those who are on the webinar, and so we will be using the real time, not the time on the wall, just so you all know.
Yes. As those new our clerks are moving out into practice, one of the things we're increasingly seeing is older practitioners, the baby boomers, who are getting older and some of whom are still practicing and suddenly can't. They may pass away. They may take ill in one way or another, physical, mental, whatever it might be. And one of the comments to the rules of professional conduct specifically says, solo practitioners should prepare a succession plan. What's going to happen in the case I'm suddenly unavailable? Designating another lawyer, competent lawyer, to review client files, notify clients when needed, and what's not here. And part of that is the trust account to make sure clients get their money back.
And even though this says solo practitioners, it's guidance for every office.
Absolutely, absolutely. You know, it's a function of a disaster plan. What's going to happen? We talked about a duty to report earlier, and there is the basic duty to report rule. When you know someone else, not yourself, has committed a violation of a serious nature, it says shall inform the appropriate professional authority. That's us. Unless you're dealing with, you know, a Wisconsin lawyer in Madison or something. And I mentioned this earlier, but here's the LCL exception that we talked about, the confidentiality that Joan has. It's actually written into the rules of professional conduct.
And all of our volunteers.
Yes, I use Joan as the personification of LCL, but really it is for LCL. It's not just a special rule for one person.
And it doesn't say we can't. It just says we don't have to.
And I'm going to not spend a lot of time on this, but what happens when you commit misconduct, which means you violate the rules, and you have a substance use, a mental health issue? And there are a couple of cases. There's this Johnson case from 1982 that talks about, and Johnson was the first case to deal with alcoholism. And what do we do with that? And a lawyer trying to say I should not be disciplined as severely because of my alcoholism. And there the court said, you know, it has to be severe, it has to be causing the misconduct. They're in recovery such that the misconduct is not likely to recur. So it's suffering, causation, and treatment such that things won't happen again. In 1983, the Supreme Court in the Wayrick case expanded this to psychological problems. The terminology over the years has changed as to how we as a society and we as a profession refer to these kinds of things. And basically they took that Johnson case and put it here. So where are we at today? Causation is hard to prove. Some things it's easier to prove, but sometimes causation can be really hard because in the end, human behavior is a multi-factor analysis. Very rare is a one-to-one correlation. And so, you know, some of that causation can be challenging. Sometimes it's simply an evidentiary issue. People don't put in the proof that is needed. But what I really wanted to get to is this. There are people who won't raise it. And I have been in meetings with people and I've looked at them and in one way or another, or in multiple ways, I've said, what's going on here? Is there something else we should know about? No. Okay. Or I'm aware for some reason that they have some sort of problem, whether it's stress or substance use or whatever it might be. And I said, if you know, this can be a factor if you want to raise this, and if you'll let us get the full information, understand it. Nope. As Joan indicated earlier, you know, some people just shut you out, and it makes it very challenging for us to try to accord the weight we need to accord to things. This is just real
I can
quick.
comment on this one. So this was someone where there clearly were mental health issues, and the court said in a comment, yeah, there's mental health issues, and we don't think that the public's right to know extends to this person's medical records. And with the permission of our board, we sent a letter to the Supreme Court saying that this comment may have saved some lives because people know that they can be open about what's going on with them and not feel like the entire world is going to know everything that's going on with them. And that's a work in progress in your office, Tim, and I'm seeing improvements. Mm-hmm. The LCL perspective is we'd like to see more.
Actually, we're working. Our files are public. That's filed with the court office. Our file is public by Supreme Court rule for our work product. That's a pretty broad rule. Bank account records, mental health or other medical records. That's a broad rule, and we're actually working to change that rule to allow for confidentiality of sensitive personal information, including but not limited to medical records, to try to help preserve that confidentiality, which obviously is a much greater concern in today's world for those of us who grew up in a pre-internet world. If you wanted to say a court file, you had to trudge down to the courthouse, you don't really go, and they pulled up a dusty file from the basement. Now Now it's a couple clicks.
Mm-hmm.
I talk about mitigation and reducing the sanctions. It's not an excuse. It doesn't say, it's not a, oh, never mind, don't worry about it. You know, nothing's going to happen to you about it. We do see people who are truly disabled. They're not confident to represent themselves or deal with us, or they're not confident to represent clients. And then there is a disability status. And that is something we used. The Clark case that Tom just mentioned was a disability case. Case of disciplinary action, obviously to be reinstated, you need to prove whatever disability you have. We have a lot of lawyers who are on probation. They're licensed to practice, but we monitor in one way, shape, or form. Conditions are tailored to the person. As Joan indicated earlier, you know, might be your analysis, might be go to an AA group, might be taking your medication prescribed by a psychiatrist. There's a whole variety of things tailored to the individual. It can be mitigation, but it is not an excuse, does not make it all go away.
So the PowerPoint, which we are not going to cover, has all kinds of stuff about issues around clients, whether the client has diminished capacity and what that might mean in terms of how you deal with them. So please take a look at this for when you are thinking about what you're going to do. And by the way, Rule 2.1 advisor is actually my favorite rule because it says you get to tell them what you think, not just the technical advice. And so to finish up, Tim had already talked about the advisory opinion service. Did you want to add anything about that?
No. There's a few restrictions. We don't talk about other people's conduct. We don't talk about your past conduct. It's a prospective advice service. But I can't encourage you enough to call. I mean, when I look at our numbers year over year of complaints and advisory opinions, there's a pretty strong correlation. When advisory opinions go up, complaints we receive go down. And so if you're ever in that situation, please feel free to call us. The other thing I will leave you all with is this notion of a self-assessment. You know, how are you doing on your own well-being?
And a reminder that we're free and confidential. You can call for guidance, help. This is the organization we work with. It's different than the state EAP. So you can double dip, actually. If you're a state employee, you can go through where you are and go through us. And sometimes if you're in greater Minnesota, they, even outside of the 7-county metro, both of the EAPs contract with the same counselors. So if you get 3 for the state and 4 for us, you can see 7, you know, you can get 7 sessions through that. So that's not a bad thing. And this is you can also contact them directly and you don't have to go through LCL. I would say that there's probably 3 to 5 people every month that we learn have gone directly to the counseling service and have not gone to the LCL office. And this is our contact information. So we have 1 minute if anybody has any questions. Questions or comments, anyone? Okay, well, I guess what we want to get across is that, you know, well-being is a part of competence. That if you're not able to do your best thinking, you're not able to represent someone effectively. And it also gives permission that if you are struggling, if you're concerned about how you're doing, if there's a case that's triggering you because it reminds you of a bully from 2nd grade, be aware of those things. What are you going to do about it? How are you going to take care of yourself? Because it's not going to get better on its own. You know, we work alone. Lawyers are actually more likely to be introverts than average. You know, you think about that. Oh, well, you're always in court and arguing. Well, very few of you are probably doing that regularly. Maybe some of you, but a lot of it's behind the scenes where you're thinking and you're figuring stuff out and you're putting something together and it's quiet. There may be a lot of pressure, but it's quiet. And so it's hard to ask for that help. And you think it'll just get better, but sometimes it won't. And over 400 people call us every year, which means that you're not alone in doing that. We're paid for in part by your license fees. And so you're already paying for it. Maybe that helps. Well, I'm already paying for it. I better use it. So really, any issue that causes stress or distress, And I hope that you'll use the advisory opinion service, and we hope that you'll use LCL. And I'll stick around, we'll stick around in case there's any individual questions. And help@mnlcl.org comes directly to me. So if you have questions that you would like to, or comments you'd like to make after this program, please send them that way. So thank you very much.
Thank you.